My name is Elmar GIEMULLA. I'm a lawyer and I deal with aviation law mainly. My main profession is aviation and aviation law, and I do it for about 40 years from now. I have dealt in the past with a number of major aviation disasters, representing victims, usually German victims, of course. Famous occurrences, famous disasters such as Lockerbie, such as Concorde case, such as the mid-air collision above Lake Constance, where a Russian and DHL plane crashed mid-air. More than 50 Russian children died there. Very tragic situation. I represented the crew against the insurer and the company. Just recently, I represented most of the relatives in the Air France 447 crash into the South Atlantic. MH17, I represent the German families, and meanwhile one Dutch family.
So how is it going with MH17 case? Because from when we last meet, and you were just starting on the case, but I remember it was really like a slow start. Nothing was really happening. How is it now, almost like 5 years on?
Very often aviation crashes are not just legal problems. They don't just produce legal problems. They are very often mixed up with a political background. Think about Lockerbie, where we had a terrorist bombing. Think about MH17 and other crashes. So insofar, it was very obvious, because whoever pushed the button, whoever initiated the rocket to down the MH17, we do not know, but it is a political affair, of course. And insofar, it was no surprise that obviously political forces, they blocked, or at least they slowed down the procedure. It was extremely difficult to find anything out. This is why I turned to my attention to Ukraine, because whoever pushed the button, one thing is for sure, that it happened in Ukrainian airspace. The airspace is part of the state territory, and each state has responsibility based on his sovereignty on his territory. Each state has a responsibility to take care of the life of the people who cross its territory. So Ukraine has opened the airspace for overflights, 700 each day, back those days. 700 planes crossed the Ukrainian airspace each day. And of course this creates, and this is just only possible if a state understands that it has a responsibility for the people who cross the airspace. The Ukraine definitely has violated this obligation. And this is not just a problem for Ukraine and for the people who died, it's a global problem. Because, sadly speaking, the east of Ukraine is not the only crisis area we have in the world. Our world is full of crisis areas, full of rebels, full of IS activities, full of terrorists who have equipment, who have heavy equipment, sophisticated equipment. So it's not just areas who are endangered, it's the airspace, parts of the airspace of our globe are endangered. And if the governments who are responsible for their airspace do not understand and do not exercise their responsibility, then global aviation will be no longer possible. So it's not just a question of what happened in the Ukraine, it's a question what will happen in the future on our globe in terms of aviation. And of course, aviation is extremely important. We cannot live without aviation in the world. The global transport of passengers and freight, of course, depends mainly on aviation. And if this aspect is spoiled, if there is uncertainty about the question whether or not I can reach the target, whether or not I can arrive where I want to arrive, or my freight shall arrive, if this is spoiled, then we are in an extremely dangerous situation for all of us.
Right. But what are the rules? Do you know? Maybe Ukrainian government warned the companies, but they just, maybe they have the right to choose whether to fly over the zone or not. How does it work?
We have no indications that the Ukrainian government warned anybody. I'm quite sure, I'm very sure that they did not, because there are indications for that. And the indication is that some days, 2 or 3 days before that disaster, there have been downings of military planes in the lower airspace. The lower airspace is up to 10,000 meters, and above this border there is the civilian overflight airspace. So what the Ukrainian government did, knowing that there is a danger for aviation in general, may it be military aviation, their own military aviation, or the flights of civilian aircraft, the Ukrainian government was fully aware of this danger. So what they did, they reacted correctly, but just partly. And to react partly means, on the other hand, it's wrong. It's not complete. So what they did was, they closed the airspace for up to the level of 10,000 to protect their own military aviation, but they left the airspace open, I mean, obviously intentionally, for the civilian aircraft. So they obviously exposed the civilian aircraft to a real lethal danger. And exactly 2 days after this, it happened what had to happen, that the civilian aircraft was hit by whomever.
It's interesting you say it, because recently the Dutch government has given a message to the next of kin that the Dutch government will support the next of kin with their court case against Russia at the ECHR, but not the family members with their court case against Ukraine at the ECHR. Can you comment on this? Why could this be? What is your opinion about this?
My experience with the Netherlands over the past years, in terms of this accident, of course, was very awkward, I must say. Of course, I started to establish contacts to the Dutch colleagues. I knew, of course, from the media that there had been a number of Dutch colleagues, I think 5 law firms altogether, who represented the Dutch families, which, as we all know, was the biggest group on the plane. So it's very common, and it goes without saying, I would say, that lawyers cooperate. At least they exchange their opinion, they exchange their strategy, they exchange their tactics. They liaise not to contradict each other, because if lawyers do it without this common and joint agreement or understanding, then it's, of course, contradictory against the interests, or can develop contradictory to the interests of their clients. And this is, of course, kind of basic ethics for lawyers, that at least they discuss who has which strategy and how possible overlappings or contradictions can be avoided. So exactly for these reasons, I tried to contact the Dutch colleagues, and there was no answer. Very strange, very strange. And of course, I reminded them after 2 or 3 months. I said, well, dear colleagues, could you please at least give me any answer? They did, again after some months, and said, well, currently we are not in a position to talk to you. So, and of course, it's all speculation. Why? From a lawyer's point of view, from the ethical behavioral rules for lawyers, it's completely not understandable. So my understanding was, my interpretation was, that there was a kind of pressure from the government, from the Dutch government to the lawyers, saying, well, okay, stay quiet, don't make a fuss, we do it for you. It's a political affair, we are the politicians, and we will deal with the affair on a political level, and please wait and see, but do not mix up and do not irritate anybody for the time being. I mean, if I put myself into the shoes of the Dutch lawyers, and I would be forced or be convinced by my government to calm down my clients and say, well, please wait, we don't do it on a legal basis, it's a political affair, and our common government will take care of it, I would hesitate to do so. It's not the task of a lawyer, not the task of somebody who represents anybody with their claims against an evildoer. It's a critical situation. If at all, of course, you cannot wait forever and a day. There must be a move, because otherwise your clients, they have a right that there is a move, that there is a development. You cannot calm down your clients over years. So my impression now is that things have changed, obviously, that the clients, the Dutch families are growingly, say, disappointed by the government. Nothing happened from their point of view. Maybe things happened behind the curtain, we do not know. But obviously, for the families, nothing has changed. So I'm telling this because the first Dutch family has approached me saying, well, we would like to join your move. I expect also other families to do the same step. And I think it's extremely important. I mean, if, as I said, whoever pushed the button, I cannot prove it. Anybody must have done so, fine. And if this is found out one day, I would welcome it very much. Of course, this was a crime and the evildoers have to be found out. So this is one thing. The second thing is the Ukraine and the airspace. And this is the only thing in all this mixed picture we know. It's proven. They have not closed the airspace for the civilian aircraft. They know exactly that the rebels were equipped with sophisticated weapons. They knew exactly that there have been 700 overflights a day, multiplied by, say, 200 passengers on these planes. So masses of people crossed their airspace, masses of people were exposed to this lethal danger, and they did nothing. They did not react. And this is a crime, definitely. Of course, I understand that they didn't want to kill these people. This would be unfair, but they just calculated with human lives. Because they exactly knew if they closed the airspace, no plane would have crossed the airspace anymore. 700 a day multiplied by the overflight charges is millions a year. Mm-hmm. Millions which are usually paid for the air traffic control, for the whole organization. So they needed the money to entertain their system. And if this money had been gone, then they would have, of course, financial difficulties. So to calculate and to outweigh the loss, the possibility of financial losses against human lives it's a crime. And as I said, this accident had to happen intentionally. The Ukrainian government exposed the lives of hundreds of people.
What about the lawsuit against Ukraine? How is it developing, if it's developing at all?
It is developing, I must say, very slowly, maybe even too slowly. But given the speed of these procedures with the European Court of Human Rights, the general speed, I mean, we are still in a normal time frame. So the average duration of these procedures is 5 years. And we have now 3.5 years are elapsed, so we are still in a normal procedure. The paperwork is done, by the way. We have filed our complaint and, of course, also explained the reasons for our complaint very extensively. Ukrainian government had the chance to respond. The first response of the government was nothing. It was something in writing, but just empty air, nothing concrete.
Generic, yeah, just something.
Nothing.
Generic. Okay.
Just explaining how the accident occurred and blah blah blah, pure blah blah. And we answered again, and of course, obviously, the Ukrainian government they started thinking about it, and then they asked somebody, obviously an expert, to add to this answer, because the second reaction of the Ukraine was much more professional, I must say. And we answered again. We could counter-argue any argument. And this is done for already 1.5 years. And now we are waiting for a hearing, for a public hearing in Strasbourg, which I expect to happen end of this year.
Oh, interesting. So what was their second answer? Also anything in particular that you can share?
Legal things, legal stuff. For example, why can these claimants go to Strasbourg, to the European Court of Human Rights? Because they have not yet exhausted the domestic remedies in the Ukraine, and they refer to any court decisions of the court in Strasbourg that the court had dismissed similar claims.
So they never said that we warned the airliner companies?
Nothing of that sort, nothing. They deny their responsibility for the airspace. They said, well, why should we? The companies should have known, and the companies were not forced to cross our airspace, and so on. And they tried to push aside their responsibility, but the arguments were not extremely convincing. They referred mainly to purely procedural aspects, to destroy the admissibility of our claim. They did not really react to the facts as such.
I would have one final question.
Yeah.
There was a Dutch lawyer. He made a comment in a question form that the Dutch government is now helping the next of kin with their court case against Russia at the ECHR. He said, how can Netherlands still be a neutral party for a court session when it takes a decision to do something like this? And then when we add the fact that Malaysia now says that the investigation from the beginning is biased, not independent, not the Netherlands, how could the Netherlands still have credibility to make a court case against Russian citizens in the MH17? You see any problem with this, or you say not really?
I see a real problem, I must say, because there are claims and lawsuits against a number of persons or organizations, against Ukraine, against Russia, against the terrorists, against Sberbank having finance. Maybe I've forgotten something. So it's a bunch of claims and court procedures. So if then, against this background, the government decides I support the relatives against Russia, then this is a decision of the government. They say, okay, Ukraine is nonsense, rebels are nonsense, this is nonsense. The only thing which is reasonable is to go against Russia. Why it's reasonable? The only explanation can be the Dutch government obviously understands that Russia is responsible, or they want to have Russia made responsible for this. So they are in fact, this decision can only be explained by that the government obviously is biased. I have no other explanation.
The other explanation could be that the Dutch have so much overwhelming evidence against Russia, which they yet still do not release.
But why then, JIT is not finished yet? Why the investigation is not closed yet? If everything is so, obvious.
That's right. Yes. I mean, if it were the case that it was the case that the government has overwhelming proof, evidence, why do they wait for the families to file lawsuit, to join the families in this lawsuit and produce then the evidence? I mean, if they have the evidence or they don't have the evidence, and if they have it, why don't they present it to the public?
Well, the official argument is that Mr. Westerbeke, the main prosecutor from the GIT, says, we do not, at this moment that the court case has not yet started, not play in the hands of the culprits and release important information about their culpability. So we would play in the hands to them if we release this information now. And that is a very normal procedure in any court case.
I never heard about this normality, I must say. I mean, if I as a government join a court procedure, as anybody. So I tell the claimants I have some evidence. Which evidence do you have? Wait and see. What is it all about? I mean, if I have evidence, I support the people who file a lawsuit either from the beginning or not. Or not at all. I mean, why to withhold the evidence and then at any court hearing, as a surprise, I say, here, I have something. This is strange and definitely not normal. Definitely not normal.
Okay, thank you.
Yeah, thank you very much.